Welcome back to Legally Speaking. I'm Melanie Fanade, and today we're talking about a critical defense in impaired driving cases that the police may not have had reasonable and probable grounds to arrest or demand the breath sample. It's a powerful legal argument and can lead to charges being dismissed entirely. With me is counsel Dan Lemaire, who is here to explain how this defense works and when it applies. Dan, why is this concept such a crucial part of criminal defense, especially in cases like DUI, drug possession, and searches?
So reasonable and probable grounds is the standard in Canada for a lawful arrest. So a police officer needs reasonable and probable grounds to lawfully arrest you in the first place. And the reason that's so important in criminal defense is because any sort of search or arrest without that reasonable and probable grounds standard can result in the exclusion of incriminating evidence. So, for example, drugs or a breath sample.
And how do you, as a defense counsel, challenge whether those grounds existed?
So to challenge an officer's arrest and argue that the officer did not have reasonable and probable grounds for arrest, we would bring an application under the Canadian Charter of Rights and Freedoms. That's a written application where we would allege that the person's right to be free from arbitrary detention was breached by the police.
And what type of evidence or errors are you looking for? Will it be body cam footage, officer notes, or inconsistencies?
All of those things are going to be looked at, but when I'm reviewing disclosure, I am looking to make sure that the information that the police relied on to make that arrest was actually available to them at the time of the arrest. What we'll often see is that police officers will prepare their notes and reports at the end of an investigation with the benefit of hindsight. And so the question is not whether that arrest was later lawful. The question is whether they had those grounds at the time of the arrest.
And if someone believes that they were stopped or arrested without justification, what should they do right away?
I would say consult with a lawyer who can review the facts and determine whether a court is likely to conclude that their rights have been breached.
And then, as a final thought, Dan, what's the biggest misunderstanding that people have about this defense?
I would say the biggest misunderstanding people have is that they try to raise this defense without the possibility of a remedy. So what I mean by that is, for example, if we have a domestic assault case where the client may complain that the police arrested them too soon without doing a proper investigation, that may be the case, but the question then becomes what remedy or exclusion of evidence are they really going to get for that? And the answer might be nothing. So it's important that you raise that defense only where it's actually going to get you somewhere.
Thank you so much, everyone, for joining us. And thank you so much, Dan, for joining us as well today. And if you want to see more of this type of content, please like, subscribe, and we'll see you guys next week. Thank you. Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defense. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.